Good afternoon. My name is Pablo Carrillo of Counsel with the Defense Public Policy Practice Group at Squire Patton Boggs and the strategic lead for the firm on congressional oversight investigations. Very briefly, before arriving at the firm about 5 years ago, I also served as the Chief of Staff to the late U.S. Senator John McCain and as his General Counsel at the Senate Armed Services Committee when he served as the ranking member, where we weighed in on issues like the strategic relationship between U.S. and China and the implications of various critical and foundational dual-use technologies on that relationship. That is, issues not unrelated to many that we'll discuss today. We're joined today by two of my esteemed colleagues. First, Ed Newberry is the Global Managing Partner for Public Policy, Compliance, Investigatory, and Regulatory Solutions. You will find few more capable and respected trusted advisors to some of the nation's largest companies anywhere. We're also joined by George Grammas, also a partner at the firm, in the firm's global legal practice, where he chairs the firm's international trade practice. In that capacity, George has distinguished himself as one of the nation's top practitioners in matters regarding export controls, sanctions, CFIUS, and other U.S. global trade, regulatory compliance, and national security matters. In terms of identifying U.S. policy and regulatory challenges to the ability of U.S. companies to do business with or in China, and developing and executing combined policy legal solutions to addressing those challenges, you'll find few more capable experts. We'll switch to the next slide, please. Ed will begin by setting the table that's providing for you a sense of where we are in terms of U.S.-China policy, specifically in the overall areas of trade and investment and its business operational implications. Where's Congress on these issues? Where are they likely to go? Where will they likely to go on them over time? What should business think about all of these developments? George will take a complementary legal practice perspective, focusing on export controls, sanctions, and regulatory and related regulatory and policy developments. And then at the very end, it'll come back and talk about how combined legal and policy solutions can be brought to bear to helping U.S. businesses overcome these policy and regulatory challenges. On how the U.S. business should think about all of this and respond operationally, I'd really like to try to keep this as an open-ended, an open, free-flowing discussion. So please do feel free to provide any of your questions in the chat box, and we'll pick them up in real time. Please note your mics are off, so that will be the way that by which you can get us questions or ask us for more information as you like them. Once again, we'll pick up your questions along the way in real time. With that, I'll turn it over to Ed.
Great, Pablo. Thank you. And thanks all of you for joining us today. And as Pablo said, happy to take questions as we go through these slides and just in the manner that Pablo identified. By way of background, George and I, you'll hear from George in just a minute, just returned from a nearly 3-week trip in China, having not been to China in a number of years because of the pandemic. It was quite an extraordinary trip in many regards, and I'm happy to talk about it. We'll talk about it a little bit through this presentation. But one of the observations that I have from that trip is how welcoming at every level, whether it be business leaders or other people working within the business community, or even just in the hotels and in the shops, how welcoming nearly everyone we met was, and how keen they are, the people we met with, are in terms of their relationships with the United States. I was struck particularly by the Chinese companies we met and how positive they felt and feel about their U.S. partners, whether they be suppliers or partners in a more formal sense. A real feeling of kinship and support. I was very surprised to encounter that, given the really extensive at the political level, the really extensive hostility that existed at that time. It's abated a little bit since then, but at that time. And that kind of leads me to the first slide, because the first slide really says a lot. It's a quote from Richard Haass from the Council on Foreign Relations. He said, "People always call for bipartisanship in this country. We have a kind of competitive bipartisanship now when it comes to China policy. Which of the two parties can be tougher on China?" And we labeled that slide "A Race to the Bottom." And in many respects, that's how it feels. And yet, as that policy races to the bottom, one thing that's happened and continues to happen is that trade with China continues to grow dramatically, showing how tightly coupled our countries are. And one of the premises that I talked about in China and that I bring to bear in these conversations is that the Chinese economy needs the U.S. economy, and the U.S. economy needs the Chinese economy. Yet, having said that, embedded in this slide is the results of a survey and from 1979 to 2023 till now. And it's America's favorable opinion of China. Reached a high of about 87% around 1987, but you can see it hovers between 60 and 70% almost continually until 2017 or so. And today it's at 15%. And that 15%, I think, is really important because I think that drives a lot of the policy making because it gives policymakers the freedom and maybe the incentive even to take a very, very hard stance on Chinese issues. They see that as very politically powerful, politically opportunistic. And that survey, I think, says a lot and will inform a lot of what we talk about today. Now, the next point, though, is the counterpoint. And that comes from Secretary of Treasury Janet Yellen, who says, "It is my belief that a wide swath of our economies can interact in ways that are uncontroversial to both governments. The fact that despite recent tensions, we set a record for bilateral trade in 2022, and as I pointed out a minute ago, it continues to go up," she says, "suggests there is ample room for our firms to engage in trade and investment." Well, there's not only ample room, it's actually happening. And so the question I think that raises is, how do we manage that competition? How do we manage what the U.S. policymakers believe are legitimate national security concerns? How do we manage that? And today's policy doesn't really seek to manage that as much as it does to really try, as the Chinese perceive, to box in particularly large parts of industry. But the other thing that's interesting about Secretary Yellen's quote is that it wasn't very long ago that people were talking about decoupling. And still in the Congress today, people are talking about decoupling. This says, as explicitly as you possibly can say, that there isn't going to be decoupling. And that's because there can't be decoupling. You can't decouple the two economies. They are too embedded and too dependent on each other. So next slide, on page 6, the state of competitive bipartisanship, to take Richard Haas's quote, in the 118th Congress. 269 pieces of China-related legislation, 155 in the House and 114 in the Senate. That's extraordinary, 269. And it goes back to that poll I showed you where members of Congress think that it is politically advantageous to take the most extreme positions in legislation that they can on China, because that favorable index is at 15%, not at 87%. And I think that's very important. But 269 pieces of legislation. When I was in China, I used this chart, and I think the number was at that time 169. And so the trend line is more and more and more.
Only thing I'd add, Ed, if you don't mind, is the 269 refers to standalone legislation.
Not amendments.
It does not refer to amendments to the National Defense Authorization Act, which is pending in front of the House right now.
And there are dozens of those amendments as well. And so you can see, I don't have to run through all these, but basically they focus in on areas like securing critical supply chains, protecting U.S. data privacy and security. We see a lot of that in the context of TikTok, securing Chinese investment in U.S. lands, and we see a lot of that activity at the state level as well, and tackling, very significantly, tackling technology threats and perceived threats from Chinese companies. The defense, I said it was 36 amendments. Next slide shows that there are 39 amendments in the House Armed Services markup of the NDAA. Again, showing a continued interest, particularly in the national security context, for legislating on China. Now, if you go to slide on page 8, think it's very interesting to see where that legislation lies. And we track all this, we analyze it, we do a lot of data analysis of the legislation and amendments that have been introduced to see where they are, what they're about, and what they do. And I won't go through this chart, but if you have them, you might look at them because it does show a lot of interesting information. Overwhelmingly, the blue boxes on the left, overwhelmingly, the legislation is about investment in trade. And secondarily, but significantly, and very close to the amount on investment in trade, is in the area in the yellow, which are basically technology, semiconductors, and the related critical technologies. And then moving over, you get to more diplomatic and reporting kind of requirements, FARA reporting and LDA reporting and the like. And you see exactly on the next slide, exactly the same pattern in legislation introduced in the Senate. It's exactly the same pattern, overwhelmingly investment in trade, and secondarily, technology. On the next slide, slide 10, some obvious points from our analysis. Number one, Republicans dominate the congressional China agenda. Overwhelmingly, the bills that have been introduced, the amendments that have been introduced are coming from the Republican side. That's not to say that there is not a lot of interest on the Democratic side. In fact, I heard one observer say the only issue that the U.S. Congress can agree on today is not the war in Ukraine, is not all the U.S. domestic issues. It's the issue of China and how to prevent Chinese competition and national security threats. In the Senate, at the Majority Leader Schumer's urging, there's an initiative to create a China Competition Bill 2.0 that'll likely be considered later on in the U.S. Congress. It's underway now. And again, you see technology, visa restrictions, and also limitations on representation, meaning trying to restrict representation of Chinese entities in the United States is a theme that comes to bear as well. Now, to take all that raw data and to put it into a context for understanding, I think what we're seeing, and this is slide on page 11, I think what we're seeing is the unprecedented, and I think that word is really important here, the unprecedented use of economic instruments of national power by the United States. It's not always it's unprecedented in its scale and scope. Sometimes these tools have been used in this way, but never at the scale and scope that is being used today. And there's an interesting quote on this slide, which I will read. The pillar one of that use of economic instruments of national power are export controls and the way export controls are being used, and the constant additions to the entity list, which we'll talk about in a second, or other export control restrictions, which George will talk about in length. And I should say that while we were in China, the interest in that subject, the level of detail that the questions reflected, the understanding that the questions reflected was truly remarkable. In every meeting, we met with 178 companies, and in every meeting, the questions were deep, thoughtful, and it was clear that the use of export controls has been something that is a major focus of those companies. And every question was about, how do I comply? The questions weren't, how do I get around this? The questions were, how do I comply? And I thought that was very interesting as well. But the Jake Sullivan quote says a lot in the context of unprecedented use of economic instruments of national power. He says, on export controls, we have to revisit the long-standing premise of maintaining relative advantages over competitors in certain key technologies. We previously maintained a sliding scale approach that said we need to stay only a couple of generations ahead. This has demonstrated that technology export controls can be more than just a preventative tool. If implemented in a way that is robust, durable, and comprehensive, they can be a new strategic asset in the U.S., an allied toolkit to impose costs on adversaries and even over time degrade their battlefield capabilities. That's an extraordinary quote. And it tells you a lot about the US policy, and it tells you a lot about the direction of the US policy. Compare that to the comments from Janet Yellen that I read a minute ago, which seemed to walk that back a little bit. But nonetheless, this gives some great insight into what the US is thinking in terms of use of economic instruments of national power. Export controls are pillar one. Look at the next slide, which is on page 12. It shows the number of Chinese companies on the entity list. In January of 2018, there were 130. As of March of 2022, there are 532. We haven't counted since, but I believe that number now exceeds 700. That's extraordinary. That's almost a sevenfold, it's a six-fold increase in the number of companies, China-based companies on the entity list. The second pillar of unprecedented use of economic instruments of national power is sanctions policy. We've always had sanctions policy, and we've always used sanctions in certain ways, but there's been an explosive growth now in sanctions regimes that can be applied, whether it be the Uyghur Acts, Global Magnitsky, Protecting America's Intellectual Property Act, country-specific sanctions, whether it be Iran or Russia or others, or even individuals who have been put on the SDN list. There is a substantial growth in the use of the tool of sanctions, or the ability to use the tool of sanctions to capture a wide range of activities. And much of this, Global Magnitsky, the Uyghur Acts, Protecting American Intellectual Property, are in fact aimed at China and Chinese businesses. Instrument of power 3, pillar 3, investment and research scrutiny. Increase in CFIUS scrutiny. We'll see on the next slide in a second that the number as CFIUS scrutiny has increased on Chinese investments in the United States, the number of applications from Chinese companies has dropped, and I'll show you that slide in a second. You've got the Restrict Act. You've got outbound investment security order coming and potential legislation restricting outbound, for the first time ever, outbound investment into China and other countries, particularly in critical technologies and in AI and in other areas like that. These are unprecedented developments. Next slide just shows you what I referred to a second ago. There were 20. In 2018, there were 60 applications for CFIUS notices from Chinese companies. In 2021, there were 17, and that continues to go down. Pillar 4, procurement restrictions. The FCC bans equipment authorizations for Huawei and ZTE. That was really the start of this pattern. The 23 NDAA restricts government procurement of products that incorporate certain Chinese-made chips. There are limits on the use of in the NDAA of Chinese drones. And so you're now starting to see procurement restrictions. You simply can't buy and use these products, and that continues as well. And the next slide, and my last slide, is I think telling as well. The House Select Committee on Strategic Competition between the U.S. and the Chinese Communist Party, CCP. That's the name of the committee. Chairman Mike Gallagher and the ranking member from Illinois, Krishnamurthy, has dove into these issues. 4 hearings this month alone in that committee, and that will continue. But to take it to a higher level, there's a committee in the Congress whose sole focus is competition with a single country. I don't think there's a precedent for that. And I think it shows you how troubled US policymakers are, how focused US policymakers are, and how important it is to navigate those shoals for US companies and for Chinese companies. And at the end, I'll offer some thoughts about maybe a new framework and a new way of thinking about some of these issues that start to restore a better competitive balance while still protecting US national security interests, because that's absolutely critical. And even those in China, our Chinese business partners, your Chinese business partners, won't argue with that premise. But there may be better ways to do it. And there may be better ways to engage, to come up with better solutions that are broader policy concepts that reflect your interests as oftentimes US suppliers, that reflect economic interests of the United States, but which still protect U.S. national security interests. But at that point, let me stop and let me turn it to Pablo if there are any questions, or to George to start his presentation. And let me end where I began. Thanks all of you for joining today. And I hope we can provide you some information that's useful.
Thank you, Ed. Just a couple of questions, if you don't mind, trying to anticipate the interests of our audience. So you talked about in some depth the economic instruments of national power that are now being used in an unprecedented way. Of course, as you know, generally the practice is for the United States government to calibrate the use of multiple instruments of national power: economic, diplomatic, military, informational, etc. Calibrate their use to generate desired national security outcomes. What do you think is the most substantial implication of the unprecedented use of these economic instruments, particularly in the context of perhaps generating anomalous or unintended outcomes?
Yeah. So, and I think that's really the big issue, the last part of your question, anomalous or unintended consequences. But I think it reflects, and this is changing slightly now, the breakdown in traditional diplomacy here. There were very few interactions among U.S. diplomats and their counterparts in the United States, as well as not just diplomats, but the various agencies, whether it be Commerce and MOFCOM or Defense to Defense or the like. That broke down. Our Defense Secretary asked for a meeting with their Minister of Defense and was denied in May. The Chinese government said no. There were supposed to be meetings in February of this year, and then the spy balloon came across the United States and changed the dynamic, and we shot it out of the sky. And that certainly contributed to and played into the fears that first survey I showed, which shows 15% favorable rating. That certainly played into that. But that stopped diplomacy cold for a long period of time. And I think it's extraordinary that the U.S. wanted and tried for a long period of time to re-engage, and the Chinese government said no. And in the meantime, the Chinese government played, in a diplomatic realm, a significant role in the Saudi-Yemen dynamic, and at the same time played a significant role, or tried to play a significant role, using its diplomatic strength, whatever that might be, to play a role in the Ukraine resolution of the Ukraine war, which obviously hasn't been resolved. And so that's why I make the comment about the strength such as it is. But until just recently, there have been no discussions. Now those discussions are beginning. And interestingly, it's not the Chinese coming here, it's the U.S. Leaders going to China. And I think that in itself is telling as well. But when you use all these tools, these blunt instruments, you do have unintended consequences. And that's where diplomacy has to step in. And I think these recent meetings, Secretary Yellen last week, and the follow-on meetings that are occurring at staff levels, and the meetings that will occur in the future, are absolutely critical. And they offer everybody who's involved in China, whether you're an investor or a supplier or a partner or even a Chinese company, opportunities to re-envision. And I do think, and I'll talk about this at the end, Pablo, the role of participants in the process, suppliers and others, is critical to getting policy right, because diplomacy is not working as well as it should here.
My second
Answer a short question.
No, great, excellent. Thank you very much. My second question is my last question before we turn it over to George. As you of course know, and you alluded to, Ed, there's been a lot of discussion about economic decoupling that's now being discussed in terms of national security de-risking. Are the two, in your view, merely synonymous? Is one an improvement over the other? And how do you see the business implications of one over the other?
Decoupling is a blunt instrument, and it's not practical. There's no way to decouple two countries that have nearly $700 billion in trade. It's just not. Our economy in the United States is dependent on the Chinese economy. The Chinese economy is dependent to some extent on the U.S. economy. We need each other. And that true north principle is going to drive things forward. That's not going to change. Those numbers aren't going down. Those numbers are going up. This is not a Cold War like we had with the Soviet Union, where there was very little trade and very little communication. This is a wholly different situation. And decoupling is a blunt and impractical instrument. And I think Janet Yellen's comments that I read a few minutes ago confirm that that's not the U.S. policy, and it can't be the U.S. policy. But national security interests are not just legitimate, they're vital and important. And so coming up with policies, and that's where people on the phone who are suppliers or think tank or investors who have good ideas, this is where I think the U.S. system of democracy, where voices can be heard and policy reflects those voices. All of you are the smartest people in the room and can come up with a lot better solutions to these problems that benefit the U.S. economy, that don't jeopardize U.S. national security, but that don't play into what's happening now, where there's a race, as Richard Haas said, to the bottom. And so I think they're very different. I think the national security interests have to be accounted for, but they have to be accounted for with sophisticated, thoughtful solutions that have less likely to have unintended consequences.
Thank you, Ed. I think that's a good transition to George.
Well, before us coming and starting this talk today, I was looking at the long list of people that have registered to participate in this webinar. And what strikes me is that there are people, many people participating from the United States, but many people are participating from Europe and some from the Middle East area. And even we have people who've signed up and are participating from Asia Pac. So I'm sorry that it's so late if you're on. But I think what that shows is that companies recognize the extraterritorial application of U.S. regulations, export control sanctions and other regulations, and probably also appreciate that the U.S.-China geopolitical relationship impacts trade and investment around the world, even if the U.S. regulations might not apply directly to everything that companies outside the United States are doing. So we hope to give you some foundation in the regulations, but also to give you some sense of where we think this is all heading, using the current regulations as the foundation for that. So on the next slide, you can see kind of an overview of where we think where this has been and where it's heading. Now, this is all driven by policy objectives in the United States to slow down Chinese leadership or development in important technologies. It's not necessarily the case that the United States in all instances has the best technology as it once could say. And so there's an element to the policy of slowing down China. Also not supporting or trying to prevent really technologies flowing to the Chinese military. And the concern is the civil military fusion in China. Maintaining our own supply chains in the United States free from untrusted content like in semiconductors, and favoring relationships with trusted policies who share similar national security and foreign policy interests in the United States. So we saw this develop in the legislation that came out as part of the 2019 NDAA. There were two bits of legislation that are important that were companion legislation. One is the Export Control Reform Act, which sort of set U.S. export controls on a new path that we'll talk about, but also the Foreign Investment Risk Review Modernization Act, which controls foreign investment in the United States under CFIUS, the Committee on Foreign Investment in the United States. And Ed had some interesting statistics, but when you look at the regulatory impact and how we see it, it goes, it also is not just about fewer investments from China, but it's also about how, for example, CFIUS is taking a really hard look at investments from non-Chinese interests into the United States to understand what are the ties between, that those foreign interests have in China versus the U.S. They want to know the details about those relationships and how that might impact their acquisitions in the United States and U.S. technology, the safeguarding of U.S. technology. We see this proliferation of companies in China that are being added to lists, as Ed said. We see not only companies targeted, but segments of industry, like the semiconductor industry or advanced computing industry in China being targeted as an industry. We have, increased, I would say, our extraterritorial application of our regulations in trying to capture the activities of non-US companies that might be dealing with China. Also, as Ed highlighted, we're concerned about Chinese content coming into certain supply chains in the United States for the U.S. government, for information communications and technology, and we are focusing on how to control outbound investment into China. Next slide. So let me now turn to export controls. And I'm showing you this slide really to define a bunch of terms so that when I use acronyms, which I will invariably do, you'll know what they mean. Now, in the United States, we have three different regimes. The first is the International Traffic in Arms Regulations, which is administered by the State Department. Now, we don't really have to focus on that during this discussion because we don't allow the items on the ITAR to go to China, not even after even the smallest amount of ITAR content in a foreign item would prevent that from going to China. So we're going to focus more on the Export Administration Regulations, or EAR, which is administered by the Commerce Department, the Bureau of Industry and Security, or BIS, or BIS. Which will control all the things that are not captured by the ITAR. This is dual-use items, but it's also some military items and space items that have been moved off the ITAR, and it's other items that in Europe, for example, they wouldn't even consider to be dual-use items we control more unilaterally in the United States. And then finally, we'll talk about economic sanctions, which are administered by the Treasury, the Office of Foreign Assets Control, or OFAC. And you can look at that, list there of countries where we have comprehensive sanctions. And some of you might think to yourself, well, there seems to be something missing from that list. And that could be Russia. But Russia is not a country where we have comprehensive sanctions like we do with Iran. But it's really not far off. We're this close to having comprehensive sanctions on Russia without having comprehensive sanctions on Russia. But instead of the comprehensive sanctions, we rely on our list-based approach of identifying companies, especially designated nationals. And for Russia, that includes, many important companies and banks. And the same thing for China. So many companies in China are now added to this SDN, especially designated nationals list. Next slide. So even those that were in the Trump administration can look at what's happened under the Biden administration and think to themselves, not a lot has changed. And that's true. And I think this next slide will demonstrate to you that in the context of export controls. So here we have a timeline of some of the important developments in export controls. And in the Trump administration, we saw this, really increasing scrutiny and new controls impacting China. And the one I think is the most important in understanding where things are heading is when BIS added SMIC to the entity list. SMIC is a manufacturer of advanced logic semiconductors. And rather than just add them to the entity list, they in a sense, imposed control parameters in the entity list, saying that if what you would like to export to SMIC is going to support semiconductors of a higher density, there's going to be a presumption of denial. But if it's not as an advanced type of semiconductor of a lower density, that the license would be reviewed on a case-by-case basis. So this is a change really in the way in which the entity list is being used, from not just listing companies, but implementing control parameters in the entity list. And we see that happening more and more. Now, after the Trump administration, the Biden administration was distracted by this little thing, meaning the Russian invasion of Ukraine, or the Ukraine conflict. And that took all of the energies, I think, of the government for many months. But when the Biden administration did turn back to export controls in October, they issued a rule on October 7th, published on October 13th, which I'll talk about in a little bit more detail, but was focusing on semiconductors and advanced computing in China. Now, I've been involved in export controls for 35 or more years, and this is the most complex rule I have ever seen come out of the Commerce Department. So if you go to the next page, I'll unpack it a little bit and show you why this is an indication of a movement in a new direction. Because first, it is an expansion of the extraterritorial application of the EAR. It caused the EAR to control foreign-made items that are based on US technology and software, or in some instances, technology and software subject to the EAR, not exactly the same thing. In many instances that weren't captured before, based on where you're sending it. Are you sending it to one of the companies we're targeting? Are you sending this product to the semiconductor industry in China? And if so, the bar for being subject to US export controls is much lower. And so many more things are captured for this, when they fit into those special rules. Next is how the Commerce Department focused more on the end use type of controls, really, not just targeting companies, but targeting that whole segment of the industry, the semiconductor industry, and defining that industry in a way to capture the part that they were interested in, the advanced semiconductor part of the industry. And then finally, they expanded the way in which the EAR can apply to US persons. So normally we think of the EAR as controlling exports, re-exports, and transfers of items, but here they used the EAR to prevent US persons from even supporting items involving China when they are not subject to the EAR. So this is another way of expansion of export controls. These are tools that were available, but I would submit used in a new and more expansive way under this rule. and probably indicates where things are heading. And so does the next slide.
George, if I could ask you
Yeah.
a quick question on that page. Are there, in terms of the extraterritorial application of the ERS jurisdiction to foreign produced products, are there any enforcement challenges that are being presented by this unprecedented, maybe not unprecedented, but this really novel development?
Yeah, well, there are enforcement challenges, perhaps. I mean, what we've seen so far as enforcement challenges is that that the rule is very complex, and it captures a lot of foreign non-US activities. And the Commerce Department has imposed very substantial penalties already on companies that have run afoul of this rule. The other thing they're doing is adding more people to the list, adding more organizations to the list, because of their role in supporting these activities that they're trying to target in China. Finally, we do see this development of the, the Disruptive Technology Initiative. Task Force. And we'll have to see how that plays out, but it's another indication that the enforcement authorities in the United States are going to continue to take a very hard line on this, because they think it's so important to national security to do it. Now, this slide is reiterating the point that a quote that Ed read earlier. But what I would say is that I would say perhaps Jake Sullivan is being kind to the U.S. position in a way, in that maybe what we have wanted to do in the past was to stay a couple generations ahead. It's not clear we're a couple generations ahead today. And so, we must maintain as large of a lead as possible. He's implying that it's more than a couple generations. I would submit we're just trying to stay ahead, right? So that we have an advantage on the battlefield. And that is challenging because China's better at public-private partnership than we are. So we have not invested in these technologies the way that China has. All right, so where are we heading? Okay, well, this complex rule I was telling you about, the final rule should be coming out soon. It's still being worked on. But importantly, we understand that the administration is working on additional controls related to semiconductor production equipment. And we haven't seen the rule yet. We're not sure where that's heading, but it's possible that that's exactly the type of rule that they're coordinating with Japan and the Netherlands. And this is trying to target like lithography equipment or testing equipment or other equipment that we want to control to reduce the access by companies in China to production equipment to make semiconductors. And but not everybody on this briefing is involved in the semiconductor industry. There's a huge range of industries represented, but my point to all of you is this is the direction we're heading, right? In terms of this type of regulation, but also in terms of multilateral cooperation. Now, we really saw that in the during the Russia-Ukraine conflict, how the US, the UK, the EU was able to move ahead in lockstep with sanctions. And this is probably the direction we're heading in. So perhaps less reliance on the historic regimes like Wassenaar arrangement, and more looking at bilateral or multilateral relationships to extend US policy by bringing other countries that are willing along to control those technologies. And we'll see more of that. Now, what technologies might come next, we'll see, but there's a lot of discussion about artificial intelligence, quantum computing, biotech. There's also concerns because we don't want to stifle R&D. We don't want to isolate the United States. And there's more thinking within Congress that we have to go even farther on the semiconductor industry than we have. Next slide. Now, there's some of what I have on this slide is a little bit technical or wonky for those people on the call who are really into export controls. But the main message is this, that products produced in China or in other countries may be subject to the EAR because they either incorporate US content in the product or they are the direct product of US technology or software, or they are produced using equipment that came from the United States or equipment that comes from another country and that is based on US technology or software. So when you stop to think about that, that can capture an awful lot of activities outside the United States. Activities in China, but also we're helping a lot of companies not in China, but that want to do business in China through their subsidiaries in Europe, for example. Next slide. Compounding that is the emphasis on end-use controls, as I mentioned earlier. So under the EAR, it says you may not. Now, you doesn't mean a US person. It means any person in any country of any nationality, any corporation. You may not, without a license, knowingly export, re-export, or transfer items subject to the EAR to it. And we just saw how subject to the EAR can be very broad, to an end user or an end use that's prohibited in the EAR. And that would include dealings with organizations on the unverified list or the entity list, depending on how they're, to some extent, that I'll go over more. Risk not dealing in transactions involving military end users or military end uses, not dealing in transactions supporting the semiconductor industry or supercomputers in a way that's prohibited by the EAR. But again, there's the word knowledge or knowingly, and it implies that you not just know who you're selling to, but what is your customer doing with those items. And for US and their subsidiaries outside the United States and for non-US companies that are dealing in items subject to the EAR, and again, under that broad definition, there needs to be a way of demonstrating to enforcement authorities that you have checked, that you don't have knowledge because you've obtained certifications, you've done some due diligence, and you're confident that you're not supporting one of these prohibited activities. And if you are not in a position to do that because you're dealing with the wrong companies in China according to the EAR, well, then what are you going to do? Because you have to discontinue business with them. You have to obtain, or you can obtain a license from BIS, which might not be possible, or you can try to sort of make your facility EAR free, or call it a clean facility. That might not be practical, and it's certainly very difficult to do. Next slide. And as it applies to US persons, again, there's a lot of information here for those that are deeply involved in US export controls. But the main point is that if you have US persons working abroad, in your non-US facility in China or elsewhere, and they're involved in a technical role, R&D or some other technical role, what they produce might be subject to the EAR and might cause your product to be subject to the EAR because now you've, in a sense, contaminated it with US technology, just resulting from the employment of US persons, right? And if you have US persons abroad who are not involved in those technical fields, but are in some function that would authorize the shipment or transmittal or transfer or delivery or maintaining or supporting, overhauling, refurbishing of items that are going to the wrong applications in China, I'm not talking about those who are just doing ministerial tasks, but those people who are in a decision-making role. They have to get out of that role, or there has to be a license for them to continue in that role, and we might not get that license. So we have to look at the US persons that are working abroad. Next slide. Now, I'm going to turn to economic sanctions for maybe 10 minutes. Economic sanctions by OFAC are different than export controls because export controls are focused on, goods and equipment, software, technology, items subject to the EAR. Economic sanctions are targeting the activities of primarily US persons dealing with the sanctioned persons or sanctioned countries. They have different let's say blacklists that I'll talk about for different reasons. They both can impose fines or penalties or add people to those lists, but fundamentally it's different because we're not under economic sanctions. We're not looking at items subject to the EAR. We're looking at the activities of US persons and sometimes non-US persons as it relates to sanctioned persons or countries or sanctioned activities. Next slide. And here you can see that it covers a lot of different types of programs, but those sanctions fall into one or two categories, broadly speaking. One is comprehensive. So those were those countries I had earlier on, like Cuba, North Korea, and Iran, that where we have comprehensive sanctions, we're not going to allow dealings for the most part. We're not going to allow any export transactions or re-export transactions or other transactions or dealing with property of those countries. But we also have selective sanctions like we have for Russia, where we have these lists of specially designated nationals, and we're blocking the property of those specially designated nationals, and US persons can't deal in their property, or basically can't deal with the specially designated nationals in any way. Next slide. Now, making sure you're not dealing with specially designated nationals can be very complicated, and it's really made complicated by this 50% rule. Basically, what this rule means is that if you have a company that's on the list here, and they have a 50% or more ownership in a subsidiary or joint venture, that entity is now blocked in the same way as if they were on the list, right? And if that entity then has a 50% or more interest in another entity, that entity is blocked just as if they were on the list, even though the top level entity on the list might have only a 25% actual ownership interest, indirect ownership interest in the lower level company. This is complicated because how do you identify those subsidiary entities and make sure you're not doing business with them? Now there you can check the lists, and there's software and different programs available to help you check lists, but this also means that you have to understand the ownership of the party you're dealing with. This is part of what I'm talking about with know your customer, right? You have to know who owns the company that you're dealing with to make sure that they're not blocked because of an SDN parent. Next slide. Plus, these sanctions can really, in a way, impact the non-US company. Up to this point, I've really focused on how it impacts US persons, but US persons have to be careful that they're not in any way facilitating the transactions that they can't otherwise engage in. This means if their subsidiary or another party outside the United States, not a US person, is involved in a transaction, there has to be a way of establishing that the US person is not approving or facilitating the transaction. Right? So that it would apply to US persons employed by the foreign entity, but also to the parent or other relationships that they have back in the United States. It means that you can't have the transaction denominated in US dollars, because if it's denominated in US dollars, you're going to have to clear the bank in New York for the exchange. And you can't even use the same IT systems as the US person parent company or US person affiliated company. Because if you do any of these things, you're actually putting the U.S. person in a position of facilitating the transaction that it can't be involved in. And the U.S. person has now violated the regulations, maybe even not knowing that they violated them because it's strict liability, not a knowing standard. But also for the non-U.S. person, they can be in violation of the OFAC regulations by causing or attempting to cause a U.S. person to violate the sanctions, for example, by causing them to facilitate the transaction. Also, the non-U.S. person is at risk of being listed. And OFAC has what we call, what they refer to as derivative authority, where they could list a non-U.S. person, not because they violated the sanctions, but just because they're dealing with SDNs. And that's a significant enough contribution in OFAC's discretion that they want to put that non-U.S. person on a list. And we have secondary sanctions in the United States, which are targeting certain countries and certain industries, but is another way in which the U.S. government can place a non-U.S. company on a list or take other sanctions that are permitted by the secondary sanctions. Next slide. And, you can see from this quote from Wendy Sherman before Congress that OFAC is really focused on cracking down on PRC entities that are engaged in activities that they're trying to target, like supporting the military or, Iran's supporting Iran in some way, or supporting Russia and its war in Ukraine. And some recent examples of companies that have been placed on the SDN list by supporting Russia include supplying technology and components to Iran for their production of drones that would then be used by Russia in the war, supplying satellite imagery to the Wagner Group, supplying microelectronics to Russia. Part of what we've tried to do is really deprive Russia of semiconductors, because you need semiconductors to conduct wars. Supplying cloud computing or other data processing machines to Russia. And look, even if you're not a Chinese company, non-U.S. companies that are really supporting China in these activities run the risk of being placed on the SDN list. So you need to be thoughtful about this and who your customers are and what activities they're involved in. Next slide. So I think that the big takeaways that I would suggest you focus on are that this U.S.-China geopolitical environment really drives U.S. trade and investment policy. And it really impacts trade and investment outside the United States with other countries, and not just in China. It impacts non-U.S. companies, not Chinese, but other non-U.S. companies' investment in the United States. We're not to a point yet where a company has to choose, am I doing business with China or the U.S.? We're not there. But, activities in China have to be defined in a way, if you want to do business with the United States, that are not going to create a hurdle to doing business in the United States. The U.S. government is actively targeting Chinese key players and industries that threaten U.S. national security and foreign policy interests. We've talked about what we've seen so far, but I don't think we've seen the end of that, and we have to keep a watch on this, because we're not, other companies and other industries might be targeted. U.S. companies and their foreign subsidiaries have to avoid prohibited transactions and dealing with these targeted entities and industries. And then finally, there are strategies available to continue to do business in and with China. And I'm not by any means recommending that you can't do business in China, but you have to take care to make sure that you're compliant, and also that you're not acting in a way that so significantly undermines U.S. national security and foreign policy interests that you run the risk yourself of becoming a target. Next slide. So that's the background on all of that. And I want to in just a minute or two, tell you about these Chinese, the blacklists, the U.S., I call it U.S. blacklists. Next slide. And the point is that there are a number of different lists. Commerce Department has certain lists, Treasury has lists. Next slide. And the problem with these lists is that if your company or another company does a search and they find a match on the list, they're going to stop business with that company. And it's going to be escalated, and it's going to have to be determined, can we continue to do business with that company? And you might find that some companies just choose not to do any business with an organization on a list. But the point is that not all these lists are the same. They have different purposes and different types of controls. And just because a company is on a list doesn't mean you can't do business with them, but you have to look at the specifics about why they're on the list. Next slide. So we have the military end user list. Now, a company will get on this list because this end user review committee, or ERC, at the Commerce, that's chaired at Commerce, determines that the entity represents an unacceptable risk of use in or diversion to military end user with respect to certain countries. Now, that would require a license for you to deal with an organization on that list, but only for when we're talking about Burma, Cambodia, China, Venezuela, only if the items are on supplement number 2 to Part 744, not all items. Now, for Russia or Belarus, it's all items subject to the EAR. If the company's on the list and the items are captured, then there's a presumption of denial, so there's not likely you'll get a license. You'll hear about the UVL list. Now, the UVL list is a much more benign type of list. This just means that BIS cannot verify the bona fides of the company. So it's been used a lot with China because MOFCOM, according to the Commerce Department, has in many instances been slow to let the U.S. persons at the embassy go and make a visit to verify the bona fides of the Chinese company. And so if a company's on that list, it means that they will, you may have to get a certification from the company before you do trade that doesn't require a license. And if it does require a license, it'll be case by case review. So it doesn't mean you won't get the license. And as soon as that bona fides have been checked, which ultimately it will be, and there's been no problem, then they will be removed from the list. The entity list is a huge problem in it for companies. And again, this is the ERC determining that there is a significant risk of being or becoming involved in activities contrary to national security or foreign policy interests. So a company doesn't have to have done anything wrong to be placed on the entity list. It's just that they present a potential risk even. And if you're on if a company's on the entity list, you have to look at the entity list to see why they're on the list because and what's captured, because it might say all items subject to the EAR, but it might have control parameters or have something less than that, as we see with, for example, with SMIC. And then the licensing policy will also be specified in the entry for the company. Specially designated nationals, that's like the nuclear option. And we can't do anything with those companies. U.S. persons can't have any activities with those companies that are specially designated nationals. There's lots of reasons, lots of different programs that OFAC administers that could lead to a company being an SDN. And then the last one is this Chinese military industrial complex, or sometimes called non-SDN list. And actually, this is targeting Chinese companies because of their perceived association with the Chinese military, but it doesn't prevent doing business with them. It doesn't prevent trade with them. It prevents dealing in their tradable securities. So you could continue to do business with them, but it does perhaps indicate that they are a military end user and that should trigger a kind of red flag for a company. All right, so next slide. That wraps up all the points I wanted to bring up. And Pablo, do you have Anything you want to transition to before we go back to Ed?
Just a couple of questions, and
I'm afraid because I heard the questions you asked Ed, and they're very thoughtful and long. So go ahead.
I think one risk that you would also add to that, and I think both of you would agree, I would call it legislative risk, and that is the likelihood that a member of Congress may seek to have a list used for an unintended purpose.
Yeah.
And we're seeing that a lot of legislative proposals exactly of that ilk, which would subject listed persons, particularly where the list may be of a more innocuous variant, subjected to potential downside that's very distinctly unanticipated.
Yeah, and I know you're tracking that for us, and
Absolutely.
that's really important because it could have a big impact on these companies.
And that's actually gives rise to my other question, and then I'll go to the question we got from one of our audience members. So I think one of the implications you laid out, I think very, very strongly, George, is the need for U.S. businesses to stay updated on changes and developments in U.S. export controls and regulations regarding national security that may impact their operations in or with China.
Mm-hmm.
How can they conceivably do that? And how can they, and this may go more into Ed's realm, but being a really enterprising and thoughtful businesses, they're probably going to want to go one step further and anticipate changes. How do you go about doing that in this context?
Yeah, right. And I think that I think the point really that underscores your question is it's not enough to just look at the regulations as they come out, right? Because it's already happened. And what you really need to be doing is thinking, where are these regulations heading? And what do I do as an organization to sort of mitigate my risk so that if regulations change, I'm not in a position to be really negatively impacted. Now, trade associations are one useful way. They're trying to keep an eye on where things are heading. And so I support that. But I think also, you do need probably to have the support of professionals who understand and can read between the lines of regulations, but also read between the lines, and this is where it gets more into perhaps Ed's comments, understand what the sense is of Congress and where are things heading, because even if there's no new legislation, comments from Congress or think tanks or out in the media and reading between the lines can really signal a potential impact on additional companies being listed, or the way in which the regulations are interpreted, or what new regulations are coming out.
And let me, we could go back to slide 19, and then I'll go to the audience question. One of the things that really came out, I think, really nicely, I think you did a really nice job in trying to rationalize regulatory and legislative outcomes that are largely ad hoc. And ad hoc is not good for business. It's unpredictable. It's unwieldy. And I know, of course, as we know, and I know Ed's very well aware of the fact that Senator Angus King and Mitt Romney sought to have adopted as an amendment in last year's NDAA, a requirement that the administration develop a cohesive, coherent, articulable U.S.-China policy from which powerful but predictable legislative and policy outcomes can flow. Is that something that you think that business should be interested in? And how helpful do you think that kind of approach would be?
I think it's extremely thoughtful and extremely helpful approach. Businesses need certainty. Businesses need to be able to understand what the rule of law is, understand where the rule of law is going, and to react accordingly. And so I think those kinds of ideas that shouldn't just be policymakers sitting in a room, but should be broader. Think tank people with deep thoughts, private industry who knows these issues cold, not just from a business standpoint, but who understand these issues deeply at a technological piece. Many of these issues, particularly when we get into critical technologies, are extremely complicated and far far more nuanced and complex than can be dealt with in a big, broad policy by people who don't understand the deeper nuances. And I think, I can talk about this in a second, but I think there's a really significant role for U.S. companies that have an economic interest to come up with better policies. And I think a commission like Senator King proposed or others have talked about, I think would be extremely valuable.
Why don't we squeeze in a question for George from the audience? What are your thoughts on the impact of Mexico becoming a U.S. top trading partner, displacing China? Seems to prove your point that we are reprioritizing low prices for Americans versus diplomacy. So this would be both of you gentlemen. Could increasing trade with Mexico ultimately be good for America, solving other issues like illegal immigration? Goes a bit beyond the scope of today's discussion, but I invite your
input. Well, I think it's a very thoughtful question because it does show. Now, still China, trade with China is increasing. And I don't think that's going to reverse. Trade with Mexico is increasing as well. And there are a lot of issues. We have our issues with China. We have very serious issues with Mexico as well that have to be addressed, immigration being one, but there are others as well. But I don't think that's a solution. I don't think in the long term that's a solution because much of the trade that goes on between the United States, some of it is not highly technical, not highly sensitive, but much of it is, and much of the value in that trade is in that area, and it's unlikely that Mexico will develop that technological expertise that it becomes a big market for those kinds of issues. So I don't see that as displacing these issues, solving these issues, but the trade dynamics will change. There's no question.
Yeah, no, I think that's right. I think at a company level, finding ways to diversify your supply chain, could be Mexico, could be Korea, could be other countries, right? But diversifying your supply chain is probably a good lesson from what we've seen, and that's in fact the direction I think the administration would like to see companies take. But I don't completely agree with Ed's point that that's not going to happen fast, and it's not going to solve. We still have to solve the problem with China. It doesn't solve the problem with China, but it's obviously a lot of what's done in China started off as a low-cost center to do for production, but over many years, China has developed really strong manufacturing capabilities in sophisticated areas that would take years, many years, to develop in another country like Mexico.
Yeah. Only thing I would add to that, I think you'd agree, George, is I think we've seen interesting reactions by Chinese business to adapt to some of these U.S. regulatory policy and legal initiatives that have been put forward, even among the very largest of these companies, are showing a degree of operational resiliency that we just really don't see with regard to U.S. companies in that scale. And I think it's certainly I'm of that view, and I believe my colleagues share the view that U.S. policymakers should really understand and assume that ability, the ability to be resilient on the other side.
Yeah.
As they.
Ed and I saw that, throughout our visit in China, that these companies are not going to just stop doing business. They're going to find a way to survive, and they're adapting and changing their business plans and changing the way they operate, and they will continue.
I think that brings us to a last segment of today's discussion. A really important implication of our discussion today is the utility, the usefulness of policy, combined policy and legal solutions that can be brought to bear in helping U.S. companies really navigate and respond operationally to some of these U.S. policy and regulatory challenges. And with that in mind, I'd like to turn it over to Ed to further discuss that.
Thanks, and we can cover this in just a couple of minutes because I think we've covered it implicitly in our discussions today. And you can see on these two slides, there's a number of ideas and thoughts. Staying informed and adapting, well, that's obviously true. Compliance, focusing on compliance. We talked a lot about that. That's very important. Developing contingency plans, that businesses do that as second nature. And I'm sure those things are happening. But there are two I want to focus on in the middle. One is engaging in dialogue and diplomacy. And I think that one of the real challenges here is that there hasn't been that level of dialogue and diplomacy. We find oftentimes US policymakers don't want to talk to Chinese companies or don't want to talk to US companies about their relationship with Chinese companies. They just don't want to talk. And that's true of some of the regulators as well who say, no, we're not going to engage in dialogue with you. I think it's critical that we all seek, whether it be a Chinese company operating in the United States, a US supplier operating in China or supplying Chinese companies, to begin and to try to force that dialogue as almost a track two kind of diplomacy, to buttress the diplomacy that is starting to occur and that will continue to occur. And I think that's critical because of what I said a couple of minutes ago. The solutions here, particularly in the areas of technology, are extremely complicated, and you can't get to good solutions with sledgehammer kind of approaches that don't take into account the sophistication and the complexity of the issues that are derived from the sophistication and complexity of the technology. You know, there's been a lot of focus on apps. There was some discussion that US would put TikTok out of business because TikTok is gathering data, they allege, and using that data or could use that data and send it back to China is the assertion, is the allegation. But TikTok's not the only app that gathers data. There are hundreds, there are thousands of apps, and they're not all in China. Some are. Some of the biggest ones are in China, and it's not just TikTok. It's a much broader problem. So why is the solution to focus on one and not develop a policy that addresses the more fundamental issue, whether that app developer resides in a country that's friendly to the United States today or not, or anywhere else outside of China? It seems to me that's a pretty good metaphor, pretty good example of differing ways to think about these problems. Should there be a policy? Yes. Should it be an enforceable policy where there's compliance? Yes. Those things are I think not debatable. I don't even think TikTok would debate that. So that's where I think the focus should be. And you apply that concept more deeply by engaging in dialogue, by engaging in diplomacy and getting deep on solutions. And as you get deep on solutions, you come up with good solutions. You also strengthen partnerships. You also improve the relationships. You establish those diplomatic guardrails in a commercial setting that we often hear about. And I think that is absolutely, positively critical. And the one right below that says maintaining strong relationships. And the one thing, I'll just close on this, the one thing that struck me while we were in China is how positively and with great goodwill, the Chinese companies looked at their US partners. They looked at them as friends, sometimes as competitors, and sometimes as business partners, but with a great deal of goodwill. And maintaining and building on those relationships both ways, China to the United States and the United States to China, can only help facilitate those more complicated solutions, public policy solutions, regulatory solutions to address much bigger issues. Because today the focus is China. but who knows where the focus is going to be next? We need good policies that protect our interests, but that allow the economy to flourish. And so I'll leave it with that. Absolutely delighted to have the opportunity to talk to this group. And if there are questions, happy to answer the questions. And again, appreciate your time for an hour and a half on a hot July afternoon.
Thank you, Ed. George, any concluding remarks?
No, I think that's
All right.
fine. Good
Well,
place to leave it.
Yeah, with that, I agree. We'll return 9 minutes back to you. We thank you for joining us and do encourage you to reach out if you think we may be of assistance to you and your business. And hope you have a nice rest of the week. Thank you.
Thanks.